case is R.J. Reynolds Tobacco Company versus Margaret Brown.
She's got the same case too.
Good morning, Your Honor.
Morning. Just wait till everyone leaves here. All right, go ahead.
Good morning. May it please the Court. My name is Jason Burnett. I'm here on behalf of R.J. Reynolds Tobacco Company, the appellant and cross-appellee. I'd like to reserve 5 minutes of my time for rebuttal, Your Honor.
All right, you may proceed.
Okay, we've raised 2 issues on direct appeal in this case. In the first issue, we've challenged the testimony by 4 of the witnesses who testified on the critical, potentially case-dispositive issue of when and where Mr. Brown's COPD first manifested itself. 4 of those witnesses came to trial and changed the essential aspects of their testimony for the first time at trial, all in ways that were helpful to the plaintiff's case. This court, other courts have reversed in situations where only one witness comes to court and changes his or her testimony or introduces new testimony. Here there were 4 witnesses. And the cases demonstrate that Binger, the Binger Doctrine, which is what we're talking about, applies in precisely these circumstances, contrary to the arguments raised by the plaintiff.
Do you characterize these 4 witness statements as a change in testimony? Because I do think that's a distinction. You said change in testimony and addition of new testimony. Do any of the 4, would you characterize it as an addition of a new category of testimony that was not covered in deposition?
So for Mrs. Longway, who was the first of the 4 to testify, she testified that Mr. Brown she noticed Mr. Brown first having breathing problems at a Cher concert in 1992. That was new testimony. I guess it's also a change in testimony because we asked her at her deposition, what do you recall about Mr. Brown and his breathing problems? And she said, I don't remember. I don't remember a timeline. She said something about he had a heart attack in 1992, maybe something around 1992, but I just don't remember.
And so that would be, I think, more characterized as a change in testimony, right? You asked a specific question and the answer changed.
That is correct, Your Honor. Yes, of course. I think Binger applies to either, but I do want to point out that for Ms. Longway in particular, the testimony changed from something quite nebulous, I don't remember a timeline, to a very specific fact about a concert, a Cher concert in 1992. And that matters because that's something that can be tested through discovery.
Why do we have impeachment?
Well,
Or cross-examination? Isn't that what it's about?
Yes, Your Honor.
I mean, people do this all the time. I mean, for whatever reason, sometimes their memory gets better, or who knows. But so the jury heard that. They heard, did they not?
They did. For this witness,
they heard what she said in her deposition, and they heard what she said at trial.
I agree, Your Honor. The Binger test.
And that's what juries do.
I agree. The Binger test requires a new trial where the impeachment is insufficient to cure the evidence. So I think the plaintiff has presented a false choice. Like it's
Binger
Binger
itself had to do with non-disclosure of a witness.
Well, impeachment was denied as to 2 of the 4 witnesses that we're talking about, Your Honor. So impeachment wasn't sufficient.
Well, I mean, really, it seems to me that Dr. Burns didn't even change his testimony at all.
I understand, Your Honor.
You agree?
I do not agree.
He didn't say what the counsel wanted him to say, but he said the same thing over and over. It became possibly probable. That's what he said. He never said it was probable. He said basically you can't do it, without a test. It would be a guess. I mean, he didn't change his testimony, and again, the jury heard all that. Well, they did hear all that.
They did not hear it in the case of Dr. Burns, Your Honor. We were not permitted to impeach Dr. Burns. So
I'm trying to think, but they read didn't they read his depo? You did,
Your Honor.
Okay. Because I don't think he changed either. I probably would have ruled the same way.
Well, I disagree for the reasons we've said in our brief. In a situation where the greater weight of the evidence is the test, the difference between something that is possible and something that is probable is a meaningful difference for the jury to appreciate, which the jury never heard in this case. And then for Mrs. Frederick, the 4th witness, we were denied the ability to impeach her as to 2 of her 3 aspects of her testimony. So impeachment was not sufficient to cure the prejudice.
Well, let me ask you this. Binger is a non-disclosure of a witness case, but it has been expanded primarily in the field of expert witnesses.
That's correct.
All right, and one reason obvious as far as prejudice with expert witnesses is it precludes the other side from going and getting an expert witness to respond to the new point, right?
That is one reason, yes, Your
All right, I know there's one layperson case where, the person changed the whole theory of the case. But let's talk about procedural prejudice. How is the procedural prejudice as to the 3 lay people who said one thing about the time they noticed something about the decedent and maybe something a bit different later on? I mean, would that be, it certainly wouldn't require you to get an expert witness, right?
Correct, Your Honor.
And it certainly wouldn't require you to go look for more lay people, because you probably already would have done that, because, that statute of limitations was defense, and whether the person was in the Engel class was already out there, right?
I disagree with that, Your Honor. I think if we had these facts, this testimony before trial, there could have been further discovery or at least further follow-up at the depositions.
Well, there are other witnesses who testified in a favorable way to the plaintiff on those issues about Engel class and statute of limitations. So you knew, at minimum, you were going to get disputed evidence on that.
Correct, Your Honor, but we were entitled to present the best case we could to argue to the jury that the dispute should be in our favor. And I do want to qualify one thing about the applicability.
But are there any other witnesses? What else would you have done?
Well, in the case with Mrs. Longway, we could have followed up with her about the details of the Cher concert to determine whether that was actually the case, whether Cher herself came to Florida in 1992 to give a concert. We don't know whether that's true or not, and we could have followed up with her on those facts and with the other witnesses as well. Binger has been applied to lay witness testimony in the Grau case, which I think Your Honor referenced, which is a 4th District case, but also by this court in the Kellner case, Kellner. That was a lay witness who went during trial to measure distances at an intersection where the accident occurred when the plaintiff's plaintiff's expert had used the Google Maps to estimate the distances. The other party, as a lay witness, went to the site and measured the distances himself and came and was going to give that testimony. The trial court excluded it under Binger, and this court affirmed applying Binger.
That's a situation where it's the middle of trial, and arguably the party that was adversely affected by that testimony did not have the opportunity to go do the same.
Well, it was
impeachment wouldn't cure that, right? Impeachment with deposition wouldn't have cured that.
You're right, because it's a question of historical fact, and here's the essential point. So the Grau case, which Your Honor referenced, makes the point that when lay witnesses testify about historical facts, that is more problematic, more significant than experts changing their testimony. Because experts can change their testimony based on new facts or evidence, and they can be rebutted by other experts. But a party is in a disadvantaged position when lay witnesses change their testimony about the historical facts. Those are the ground rules. Those are the facts that lay the ground rules for
You would agree, though, that the abuse of discretion standard still applies even in light of Binger. And the trial court in this case was in a better position than we to determine what else the parties could have done, how this testimony was affecting the trial, and chose to allow impeachment in certain circumstances, and then to determine there wasn't a change in testimony in certain circumstances. And how can we, sitting where we are, say that the trial court acted as no other reasonable judge would have done?
Sure. So a couple of parts to your question. One is, does the abuse of discretion standard apply? Yes, it applies. The abuse of discretion standard also includes within it, though, legal questions are reviewed de novo. Plaintiffs have raised some arguments about whether Binger applies. I think those are legal questions, and so there's no real deference given. Does Binger apply to lay witness testimony? Well, it does under the case law. Under this court's case in Kellner, that's not an abuse of discretion question. As to the trial court being in the best position, the trial court gave one reason for denying the motion for mistrial. There's no reasoning given in the order denying the motion for new trial. The one reason given was no prejudice to Reynolds. And yes, that is an abuse of discretion, because Reynolds in its opening statement said, listen for the evidence about Mr. Brown and his inability to carry on activities like playing basketball while he lived in New York. Listen for that evidence. And what happened? The first fact witness that testifies, Ms. Longway, changes her testimony from, I can't recall, to it first happened at a Cher concert. So Reynolds' trial strategy, planned in advance, reasonably based on the deposition testimony, was articulated to the jury in opening statement, and then it was changed during trial. And this is the key point. the jury asked for a readback of Ms. Frederick's testimony, the last witness, the fourth witness that we've challenged. And plaintiff's counsel admitted during phase 2, well, they were evidently interested in the manifestation issues. That's why they asked for the readback. So we know particularly in this case that the jury was interested in the manifestation testimony of Ms. Frederick because they asked for that readback. And so it's an abuse of discretion here to find no prejudice when the rug was pulled out from under Reynolds on the basic facts of the case. I'd like to turn to the second issue, if I may. It's an important issue as well. So in this case, the trial court expressly ruled that plaintiff could recover punitive damages for conduct in phase 2 or for claims, conduct underlying claims in phase 2 that the jury had rejected in phase 1, the fraud claims. There was no wiggle room about this. We asked for an instruction to tell the jury, you cannot impose punitive damages for that conduct. That was denied. We said to the trial judge, we want to argue to the jury that they can't impose punitive damages for that conduct. The court said, no, I'm not going to allow that argument. And then plaintiff's counsel got up and made arguments to the jury asking for an amount of punitive damages based on lying to the public and filter fraud, and even asked questions of our witness in phase 2 about whether filters are indeed safer than non-filtered cigarettes. And we objected to that closing argument comments by plaintiff's counsel, and those objections were overruled. So 3 different types of rulings on this issue in phase 2. And the key point, I believe, is this. We know from the Florida Supreme Court's decision in Murata that the basis for the strict liability and negligence claims is nicotine manipulation. The allegation that the tobacco companies can change the level of nicotine to keep smokers addicted. In this case, the basis for the fraud claims in the phase 1 closing arguments by plaintiff and again in phase 2 was what's called filter fraud. The allegation that the companies marketed filtered cigarettes as a safer alternative, knowing that they're not safer. That was the key allegation in this case of fraud, filter fraud. Filter fraud is not nicotine manipulation. It has nothing to do with the levels of nicotine in cigarettes. That was the basis for the fraud claim. That was again the basis for asking for punitive damages in phase 2. But we know from the Florida Supreme Court that filter fraud is not the basis for the strict liability and negligence claims.
What's the burden of proof on the fraud? Was it clear and convincing evidence?
It was, for the fraud claims, it was preponderance of the evidence. Then on punitive entitlement in phase 1, it was clear and convincing evidence. And then in phase 2, on the amount of punitive damages, it's back to preponderance. Okay. If that makes sense. It is confusing. But this was just clear legal error. And as opposed to the Binger issue, Judge Sasso, which does have aspects of discretionary review at issue, this is a legal determination that a plaintiff can recover punitive damages for conduct underlying claims that a jury has rejected.
And let me ask you this. The jury was instructed that the amount of punitive damages must be based only on conduct causing harm to Arthur Brown.
That is correct, Your Honor.
All right. So what would your proposed instruction that was rejected add to that?
So we proposed an instruction, I don't have it in front of me, but it said you may not award punitive damages for the concealment or conspiratorial conduct in phase 1, from phase 1.
And I have a similar question. If the jury, let's take the assumption that the jury followed the given instruction and that they did not assign damages for conduct that did not cause harm to Arthur Brown. In that case, would you agree that that instruction was sufficient?
If we could know that the jury did not... No, Your Honor, I still think it's insufficient because you have to, this court and the jury must consider the jury instructions as a whole, correct? And the other parts of the instruction that were given, not just the one we requested that was not given, but that was given, was to tell the jury to consider all of the evidence from phase 1. So they were also instructed, although they were instructed to award punitive damages only for conduct that harmed Mr. Brown, they were instructed to consider all of the evidence from phase 1. And this jury,
even though in the face of your proposed instruction, that instruction still would have been given, right? All of the evidence?
Yes, Your Honor, but They would have been, it would be a limiting instruction. It's just a limiting instruction not to consider certain evidence that is no longer relevant in the phase because of their determination in phase 1 that there was no fraudulent conduct on which Mr. Brown relied or that was a legal cause of his injury. So that instruction would have balanced out the instructions to correctly inform the jury of the boundaries of what punitive damages could be imposed for. And the other point, too, is that I'm not sure the jury can appreciate, because we have to take a step back. The jury's not instructed on strict liability or negligence in an Engle progeny case. Under the Supreme Court's decision in Douglas, the class membership question, which is just were they addicted, was addiction a cause? That substitutes for strict liability and negligence. So I think it would be, at a minimum, confusing to the jury to hear argument about filters and filter fraud and not know or not appreciate that, oh, that goes to the fraud claims that I've already rejected and was not a cause of injury to Mr. Brown. They may think that that has something to do with the strict liability and negligence claims that they're told are at issue in the case. It's just part of a statement of the case, but they're never instructed as to what strict liability means or negligence means, because there's no finding about those things in these cases.
All right, you're at 5 minutes now.
Okay, thank you, Your Honors.
Good morning. May it please the court. My name is Celine Humphreys. I'm with Brannick and Humphreys, and I represent the appellee. I did also raise what we called a conditional cross appeal. I don't know if we proceed forward on that, how you want to handle dividing up oral argument today.
If you argue that, it'd be part of your 20 minutes, and then they'll have an opportunity to respond. I think it'd be helpful probably to respond first to the issues raised on appeal, and then if you want to add anything on the cross appeal, you can do so. And
Okay,
then they'll have a chance to respond to that.
Thank you, Your Honor. Appreciate that. So as you know, there are actually 4 issues raised by the defendants. The only 2 that they raised that are de novo are these arguments, constitutional arguments regarding due process and preemption. They've put a bookmark in the pleadings here. They're walking away from those. I do want to let you know that that argument has been denied over 100 times by appellate courts, and 35 petitions to the United States Supreme Court by R.J. Reynolds on those 2 issues have all been denied. So that leaves for us only the 2 discretionary issues that were argued at length to you today. Given all of your comments on issue 1, the only thing that I want to add, which I thought was there's 2 things I want to add unless you have more questions. This argument that Binger extends to lay witnesses, there's no decision that says that. It is a reckless concept for our courts. And the one decision that they do rely on, we took some time in our answer brief to quote it to you, the main one that they cite, and that's Menard from the 4th District. And they ignored critical portions of Menard. So if you don't mind, I'd like to direct you. It's page 71 and 74, where that court specifically says, quote, "We limit our holding to the facts and circumstances of this case." And that was where a party changed its testimony, where one representative of the corporate entity said one thing in the deposition about how much a medical bill is. Right. And then the court concludes, under the circumstances here, our holding is in the nature of an estoppel. There's nothing like that here. The other thing is, just a little bit more on this, I think you asked this, you made this point, Judge Evander. There were actually 8 different witnesses on this point. There were 8 different witnesses. And the defendants objected, out of everything they talk about in their briefs, the defendants objected to only one witness's comment, only one comment by that witness, and even then did nothing close to a sufficient objection, and certainly not the standard of Binger. And the point there is, this process of preservation of error, it's not just a cute get-out-of-jail-free card by an appellee. Preservation of error is actually not about preserving error. It's about avoiding error. You don't wait 3 days and file a mistrial motion. You don't file an appeal citing all of these objections you never lodged to the trial judge. You have to tell the trial judge that there is error occurring that is of such significance that if it's not corrected, there will be a new trial. That's what preservation of error is about. And if you have no other questions on issue 1, I'll turn to issue 2 about the jury instruction. Likewise here, Judge David Walsh enjoyed broad discretion. There's a couple of points here. This issue is also fact-specific, but the easiest one, I think, is what you asked, Judge Sasso, about the jury instructions. Just for a moment, based on your question, Judge Evander, when we have punitive damages, a defendant can elect to have a second phase where if the jury in the first phase says thumbs up, yes, this conduct warrants punitives, we'll come back in the second phase and talk about how much. In the first phase, just like any trial, it is not uncommon for multiple causes of action to be before the jury. On the same story, on the same factual story. That's what happened here, 4 causes of action. And in the jury instructions, when the jury went on to decide whether or not to impose punitive damages in phase 1, a standard jury instruction covered this. A standard jury instruction that is given in all sorts of cases where there's more than one cause of action based on the story. And that's the one that clearly said, punitive damages are warranted if, jury, this is your thinking, 1, you find that the conduct causing injury resulting from COPD or emphysema to Arthur Brown, and then 3 other factors, all saying the conduct you find caused, the conduct you find caused. That disposes of the issue. I can't help but also refer to my second argument in response as to why they're wrong here. They have to show you a case that says when you happen to lose one of the causes of action that could have been brought on this story, that all of a sudden the evidence evaporates. They did not. We did in our answer brief. And we went back to 1999 and cited Owens Corning versus Ballard. That's an asbestos case. There was no fraud cause of action. It was purely a products case. And when the Florida Supreme Court delineates the factors for punitive damages, because that's what the Florida Supreme Court was doing in that case, reviewing the punitive award, one of the things the Florida Supreme Court expressly considered was, quote, the degree of reprehensibility of Owens Corning's conduct, the duration of that harmful conduct, Owens Corning's awareness, and concealment. Concealment was evidence relevant in a product case of whether or not to impose punitives. And I take issue, the only attempt that the defendants made to distinguish Owens Corning is to reference a comment elsewhere in the decision about a constitutional problem. And what R.J. Reynolds suggests, and it's the last brief filed to you, R.J. Reynolds suggests that the Florida Supreme Court held that there's constitutional implications of allowing a punitive award based on facts that might also be relevant to another cause of action. And that was a reckless statement. The constitutional reference there was a wholly different issue. I won't get into it in too much in depth, but the point is, under the federal Constitution, the United States Supreme Court has said when you have punitives, we're going to impose a kind of limit on them based on the Constitution. It's a due process kind of thinking, and it's based on ratios. If your award is $2 million, then the punitive damages can't be more than roughly, it's supposed to be single-digit multipliers. It's a wholly different argument, and they know it. I have oral argument against R.J. Reynolds on this issue tomorrow. So that's all they offered to distinguish Owens Corning, and it's a wholly different argument. And they never responded to another case of theirs from the 8th Circuit. The 8th Circuit Court of Appeals expressly rejected this very argument, albeit there the dispositive ruling was in a summary judgment, not by a jury. Same point. Expressly rejected. I had to go hunting for that case around the state. It's their case, around the country, excuse me. That being said, our issues on the cross appeal are really, truly conditional cross appeals. We don't seek this court to review those rulings unless you are truly concerned about the verdict. And so for that reason, unless you have any questions, I'll stand on my papers on those. And I appreciate the opportunity to appear before you.
All right, thank you.
Thank you.
Thank you, Your Honors. I think I said the Grau case about lay witnesses. My opponent is correct. It's Menard. Menard says something about we're limited to the facts and circumstances of that case, but it goes on in depth for paragraphs explaining why lay witness testimony about the historical facts of a case are more significant than expert testimony. So it reinforces the point that Binger does apply to lay witness testimony about historical facts. That's what we're dealing with.
Can you address the preservation argument that the motion for new trial wasn't filed until 3 days after, especially in light of the abuse of discretion standard?
Sure. So we did object to the first witness on changed testimony. My opponent's argument is that's not the correct objection to raise. I don't know what other objection we should have raised besides change testimony. If you look at that exchange, we said change testimony and the trial court cut us off and said take it up on cross. So we weren't even allowed to make the full objection we wanted to make. The objection, though, as made, was sufficient. Change testimony is invoking Binger. We objected to the first witness. The next witnesses testified. We impeached those witnesses. And then before the fourth and final witness, Ms. Frederick, testified, we filed a motion for mistrial. We emailed the other side. We said, 3 of your witnesses have changed their testimony on this issue. Is this fourth witness going to change her testimony? And then we filed the motion for mistrial, noting even before the fourth witness had testified that there was a grounds for a new trial. And then the fourth witness testified. So there can't be any argument as to Mrs. Frederick, the fourth witness, when we raised the motion for mistrial preemptively before she even testified. And then the objection to the first witness was certainly sufficient to raise the Binger issue when we invoked change testimony as the basis for the change. Turning to the second issue, multiple causes of action. Ms. Humphreys is reading to you from the jury instructions given in phase one of trial, when the jury had yet to answer the liability claims. So at that point, they had not yet decided that the fraud claims were not the basis for liability against Reynolds. So we're talking about phase 2, after the jury had already decided that there was no fraud that was a cause of harm to Mr. Brown. Then we're asking the jury to be further instructed, well, you can't consider the conspiratorial or the concealment conduct because you've rejected that conduct. And again, there is reason to believe at a minimum that the jury was confused about this issue.
How do you distinguish Owens Corning where they didn't even bring a fraud count? They just brought the negligence, strict liability, and then I guess some evidence came out about misstatements, et cetera, and the Supreme Court said it was okay to consider that for punitive damages, even though obviously the jury had not made a finding of fraud because it wasn't before them.
Right. So 2 responses on that issue, and this applies to Ballard, the Jansen case from the first DCA, and the Berner case from the 8th Circuit that was just mentioned. There's not any indication from those opinions that this issue was raised, that the defendant said, wait, there's no fraud claim in the case, therefore you can't consider fraud evidence. So there's no indication that the issue was raised. But it is true, as counsel notes, that those courts did look to certain types of evidence in supporting higher awards of punitive damages, and some of that evidence sounds like concealment evidence. I will note that at least in Jansen, there was a failure to warn claim. Failure to warn sounds in negligence. I know it sounds like concealment, but it's a negligent cause of action. And so when the claim is failure to warn, yes, the not taking steps to apprise the public of the harm can be a basis for both negligence, failure to warn, and punitive damages. But the key is this. It is true under Florida law, to get punitive damages, you have to have the compensatory claim, the conduct for that claim, and then there's a separate sort of mens rea requirement for punitive damages, right? Has to be gross negligence. You can't get punitive damages from mere negligence. Has to be either grossly negligent or intentional misconduct. That's true. So if the claim in an Engle progeny case is that, well, for your negligence, cause of action, you, defendant, manipulated the levels of nicotine in your cigarettes to make them more addictive. Well, fine, they can ask for punitive damages based on evidence that we intentionally did that, or we're grossly negligent about the levels of nicotine in our cigarettes. So I'm not denying that in some cases it's appropriate to consider evidence of conduct above and beyond the conduct of the claim to meet those mens rea requirements for punitive damages. But it has to be based on the claim for compensatory liability. Otherwise, you're punishing the defendant for claims that are unrelated to the harms of the plaintiff. And Ms. Humphrey criticizes us for not citing a case. We cited State Farm versus Campbell, the United States Supreme Court, which said the Utah Supreme Court was wrong to justify $145 million in punitive damages for conduct about State Farm's bad acts in general that had nothing to do with the claim that they refused in bad faith to settle the litigation at issue.
All right, your time is up. Thank you both.
Thank you.
And we'll take a short break.